All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well from the prior testimony.
And all the exhibits as well.
Yes.
Right, then the state would also offer State's Exhibit A into evidence, pending any objection from the defense counsel pursuant to Rule 902.
I object on lack of proper.
Right off the bat. Notice how the defense is already on the offensive. Objecting this early is a classic tactic call, most like planting a seed of doubt in the jury's mind. Do you think it works here? Or does it just make the defense look desperate?
Found you guilty of count 1 of aggravated assault with a deadly weapon. And they found you guilty of count 2.
And there it is, the first guilty verdict. That phrase alone carries so much weight. Remember, aggravated assault with a deadly weapon isn't just a fight, it's a serious felony with life-changing consequences. What punishment would you expect at this point?
Right. State, if you would read out the enhancements.
For count 1, before the commission of the alleged offense in clause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and clause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, precision gun. And before the commission of the primary offense and after the conviction in clause number 94 CR 5960 was final, the defendant committed the felony of assault, family violence enhanced, and was convicted on the 29th day of January 2013 in clause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in clause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in clause.
This is huge. The phrase repeat offender means the state is stacking prior convictions to enhance sentencing. Translation: the stakes just skyrocketed. Once someone is labeled a repeat offender in Texas, probation is pretty much off the table.
With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, the state will waive opening.
Waive opening.
All right, state, you may call your first witness.
Preliminarily, the state, that, Your Honor, the state would like to offer and admit all testimony and evidence that was heard in since days of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well from the prior testimony.
And all the exhibits as well.
Yes.
Right, then the state would also offer State's Exhibit A into evidence, pending any objection from the defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Mia Valdez.
All right, state.
Ms. Valdez, could you please tell the court what your area of expertise is?
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And at least you possess some.
Yes, I have a certification in classifying fingerprints as well as identification.
Please explain what those.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprints specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not in my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts, and we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, is that just your way of doing it, or is that just the way?
That's the standard way.
That's the what way?
The standard.
Can you take the witness on board diary?
Yes.
Okay. I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay. And so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay. But you were not saying you took those prints?
No, I didn't.
Okay. So you don't know my client, right?
No.
So you can say that the prints match, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally, right?
No, ma'am.
And so you can't say you didn't witness that, who the person was who gave the prints.
Correct.
I would object to relevance and lack of affirmative link to my client.
All right, and so is the testimony,
I'm sorry.
was it established who these prints and State's Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in State's Exhibit B?
Yes.
She did testify as to the individual that she talked about that individual today.
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint states at the B today, correct?
Correct.
You see the person in the form that you took those fingerprints from?
Yes, sir.
Would you please point to that person and identify him by ocular photos?
Thank you, the gentleman in the red.
You represent the records reflect that this is identified the person that you took the fingerprints from, the State's Exhibit B.
All right. Defense, any objection with regards to State's Exhibit A and B?
I re-urge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right, those objections will be overruled. State's Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true, and the court is finding.
Here's where things get technical. Fingerprint analysis may sound like TV drama, but it's very real science. 12 unique points matching. That's enough to positively identify a person in court. But here's the twist: can the defense poke holes in how those prints were collected?